You're listening to the Retirement Architect, David Reyes.
Here with Brenda Geiger, a state tax and business attorney from USD Law here locally in San Diego. Our article from the Wall Street Journal, what you had is you had somebody who had a $400,000 plus inherited IRA, and they stretched it out, which means that instead of taking a lump sum, they took it over their life expectancy, which is great because instead of paying all the taxes up front, which could be 50%, they took it over their lifetime, which was a smart move, correct?
Yes.
And then what happened was that they filed bankruptcy and they thought everything was hunky-dory because they had this amount of assets that they had not taken any distributions, these IRA assets they inherited, and they felt that they were protected against bankruptcy. And the Supreme Court said, no, they're not. They're subject to bankruptcy or creditor laws, and they're not creditor protected. Is that a fair summary?
Yes.
And so how do you fix this then, Brenda? What are one of some of the fixes that you use, the strategy you use to create this asset protection moat, so to speak, around the IRA so we don't have these problems in bankruptcy or divorce or, what I call the slip and fall, or somebody gets killed in a car accident and they go after your assets? How are you having to devise special trust to do this, or are you doing it within the existing living trust?
Typically, we like to do this in a specialty trust called a retirement protector trust. Sometimes you'll hear them referred to as retirement plan trust or IRA trust. And they're specifically devised just for this particular type of asset. So there are certain provisions we will not put in there because they could interrupt or interfere with creditor protection of the required minimum distribution. So although you can build in conduits into a revocable trust, which we actually routinely do that for everybody anyway, but on top of it, we can protect the RMD that comes out, which, surprisingly, even on a smaller amount of money, if it's stretched over, somebody who's one generation below you, you'd be really surprised at how big that RMD could be later on down the road. And there are calculators that we use to show clients this, and it's just absolutely astonishing. So this trust I'm talking about, the Retirement Protector Trust, it becomes either, if it's a single person, the primary beneficiary of the IRA, or if they're married, usually it's the spouse that's the first beneficiary, the primary beneficiary, and then the contingent beneficiary is this specialty trust. The trust that acts as a barrier, or like you called it, a moat, between the creditor and the distributions that are going out to the child or grandchild, because sometimes it can be grandchildren too. Or if a child dies, then the grandchild can then take over their parent share. So it's really an interesting way to continue to provide, kind of a paycheck for life for children and grandchildren.
We're talking about protecting the assets from creditors, but what about taxation? Explain to our listeners how we can actually help their beneficiaries to save taxes, as you kind of alluded to a little bit, on an inherited IRA.
So for taxes, when you inherit, a lot of people don't realize that you can stretch that 401k or that IRA. It's just that you need to request that from the custodian. Mm-hmm. So that's a key thing, and you cannot rely on the custodian telling your child or your grandchild, that they have this ability to do it. It's not in their best interest to split the account between, 2 or 5 people. They have a cost structure to maintain. So you have to be proactive with that. So making sure you have that stretch, because if it stays in that tax deferred environment on the front end, if you're a California resident and let's say you accelerated $300,000, $400,000 worth of income onto your return, that's going to put you in the top tax bracket. So between federal, state, and all these new laws, the 3.8% surcharge, all this stuff, you're looking at over 50%. So that account's going to basically be chewed up by more than 50% in taxes. So even if you decide to take the lump sum distribution because you want to go buy a new car or buy a house or whatever, you're really, messing yourself up. You're not getting that tax deferral where it can stay in that tax deferred environment longer.
So again, to reiterate, just to make sure that you understand this, is that basically what she's saying is, an example, let's say somebody has $1 million in an IRA or 401k, whatever, a pension plan. If that child inherits that money outright, they could pay up to 50% income taxes in that particular IRA, because there's been no taxes ever paid. So we're not talking about estate tax, we're talking about income tax. And so what will happen is they would lose $500,000 theoretically of assets to where instead we can asset protect or creditor protect this and make sure the taxes are paid as like a personal pension plan for their children and grandchildren for the rest of their lives that can equate out to 5 times or more of the assets. But just imagine that you're going to give 5 times more money to your children and not be paying the government 50% of the income taxes. I mean, that's a big deal. So for, most clients that have children and have large IRA assets, this is something, Brenda, I can tell you, and from experience of us working together, that there's a lot of interest in, because it's something that, that people are not comfortable saying, hey, I saved all this money, and if something happens to me, I don't want the government getting 50% of my assets. And on top of that, I could increase it 5-10-fold just by doing this particular planning. So if you want to have this type of planning, you want to have Brenda do a complimentary review, receive a copy of one of her books, give us a call at 1-800-611-1967. Again, it's 1-800-611-1967. So again, if you're having interest in receiving a complimentary review of your estate or of your trust, again, give us a call, 1-800-611-1967, and we'll arrange that for you and also get you out a copy of one of her books, of her potpourri of books. We're running out of time here a little bit. Is there anything that we've left out, or what point would you want to reemphasize that we've talked about that you think is really important for our listeners?
Well, we didn't bring this up earlier, but I feel really compelled to talk about it. Not just the basic statutory power of attorney, because, there's so much of the population that's aging right now. And if we have what I call an expanded durable power of attorney, it's a custom draft that we add on to our plans in addition to the statutory, because the banks like the statutory, they're familiar with it, but there's so many other applications for it. If we need to move assets around to save estate taxes, or if we needed to get Medicaid because now the person is starting to run out of money, now that all they have left is their $1 million home and a couple $100,000 in a brokerage, we need flexibility if you become incapacitated. And if we don't have that flexibility, we're just kind of stuck. Some things we can go to court for and get court approval. Other things the court is just not going to allow to happen because, it's just against what they're going to do.
So what is the standard powers of attorney, Brenda, and repeat, just so I want to make sure listeners got this. What is the power of attorneys you're talking about that give us more flexibility?
So I call it an expanded durable power of attorney.
Yeah, expanded. Okay. As opposed to statutory so give me an example. So a statutory, power of attorney is basically going to be more generic in sense. And if a client becomes incapacitated, you can't change that power of attorney, correct?
Exactly. Yeah. So it's just going to cover basic things like, tax return filings, dealing with banks. There's a whole, it's in the state statute. You can look it right up online. But It's just what the state has said. This is what, is in the basic power of attorney. So that's how we generate that power of attorney. So banks are very familiar with it in California. But the expanded one has, the one we draft has like 28 additional powers. Has powers over gifting, over disclaimers, over setting up a Medicaid trust or other types of trust if we needed to. So there's just a whole litany of other things that we could do that if you're incapacitated, we're not going to be able to do unless your power of attorney agent has that power to do it.
And I know from experience, we have clients, Brenda, that in 1 week, Brenda, I had one client that had brain surgery and another client that had a double stroke, in 1 week. And unfortunately, one of my clients of 17 years just passed away. God bless him. And, now I'm dealing with a lot of obviously the after, the after planning. We did the trust, we did long-term care policies, we did life insurance. We did all the planning, thank God for them, 17 years ago. And when people didn't really know what planning was, advisors didn't. And I thank God that we did that for this family, that we're very close to. And unfortunately, he did not survive his brain cancer. And then I have another client, similar situation, that just went through having a double stroke, and she had 10% brain capacity, believe it or not, Brenda. And now she's in rehab, and she's not perfectly fine, but we thought she was not going to make it. 10% brain activity is not high, and it's basically brain dead. And so it's a miracle that she's alive, not even a question. And these are all issues. The reason I bring these up is these are real life stuff that you and I deal with every day. And these are situations that could cause, if you had too stringent of power of attorneys, there's a lot of planning and things that may not be able to be done that I can tell you from experience, and you even more so from your experience. And I'm just glad because, see, most people don't realize, Brenda, that most trusts are, when you pay for the $250 trust, it doesn't have these provisions. These trusts that are done generically, they don't have these provisions. They don't have these special IRA trusts to save taxes, for asset protection for beneficiaries. So I really do advise that you do give us a call, and we'll refer you to Brenda. You can get a copy of one of her books, whichever one you choose. We'll set up a complimentary second opinion with you, with her, relative to your trust, wills, estate, business tax, entities, anything. But she's just all around a really good attorney. So give us a call at 1-800-611-1967. That's 1-800-611-1967 to set up that complimentary second opinion for that. And Brenda, what is give out your email address again, please, so they can, anybody who wants to look you up online can do that.
Our web address is GeigerLawOffice.net, and Geiger is Geiger. And we do have a contact page. And then if anybody wants an advanced copy of my new book on Retirement Protector Trust, I'm willing to share that too.
Oh, good. Well, that's awesome. Well, Brenda, I appreciate the time we've gotten to spend together, and you're so great about, putting this in plain English. And even more so, I would say, the radio is a tough medium for this. But I wanted to at least, break the ice and have our listeners have the opportunity to hear you, and more importantly, take the opportunity to meet with you. So again, if you want to meet with Brenda, give me a call, 1-800-611-1967. As a KFMB listener and a listener to the Reyes Financial Architecture Show, your retirement architect, you will get this complimentary second opinion of your trust, which normally I will tell you she charges around $1,000 to do this, because it is very, very thorough. Believe me, I've seen her notes for my clients that she writes on these, and they're very, very thorough. And it's nice to see that. In fact, when we first met, Brenda, I said I couldn't believe how much work you put into these trusts, and that's where you and I are alike. I do a lot of work pro bono, basically ahead of time for clients. If I think it's a fit, to help them, because it takes that to be able to figure out if you can help and how you can help, right?
Exactly, yeah.
Yeah, so please take advantage of this, and we'll have Brenda on again. But again, if you'd like to have this complimentary second opinion, it's 1-800-611-1967. Again, we're here with Brenda Geiger, local graduate from USD Law. So I appreciate the time, Brenda, and we'll love to have you back again sometime, which I hope will be soon. And again, thank you for your time today.
Yes, it's been my pleasure.